Again, Attorney Steve Vondran, we're back, and we're talking in this video episode about officer and director liability in software cases, infringement cases, copyright infringement cases, and probably just general tort cases for that matter. So without further ado, let's head to the Attorney Steve litigation whiteboard. All right, back this baby up. Let's back this baby up if my battery's working here. Okay, there we go. You got to get your boxing gloves in there, duking it out in the streets, fighting for your legal rights. In this case, your software audit legal rights, okay? So this is going to be geared toward that company that gets that, what we call the love letter. You get a letter from the SIIA or the Software Alliance, the BSA, Microsoft, Autodesk, Adobe, and hundred of other different software companies where you could get a demand to audit your files. One of the questions I get, I end up speaking with a lot of CEOs, CFOs, CIOs, CTOs, IT directors, you name it, anybody that's head of the top brass of the organization. And one of the questions that some of the companies have that comes up quite frequently is, am I going to be held personally liable, or is the corporation liable? In other words, if we're found to be infringing of software, or we're software pirates, am I going to be held personally liable? I do not want to be held liable. And so it's an interesting question. So I want to talk about this topic. I've got a little picture drawn up here for you. I don't know if you can see it. I may have to get a little closer. But so here's your corporation. Here's your little shell here, and we called it, there's the corporate. That's my little picture representation of a corporation. So the corporation, usually the reason people incorporate is to protect themselves from personal liability. Over here you have your president. Oh, I got totally nipped out of there. Over here you have your president and your CFO, your CTO, the people that are in your articles. They're named as officers, directors, president, secretary, all these officers, right? And you have some shareholders down here. But the question is, in these software audit cases, if this company is found to have infringed software from this company, the plaintiff, we'll just call him the plaintiff, okay, pretending it goes to a lawsuit and you can't get your audit settled, and it goes to a copyright infringement lawsuit, you may have the plaintiff coming in here to try to hold somebody liable. And the question is, can this plaintiff hold this corporation liable? Yes, well, naturally they would sue the corporation, would they not? Yes, naturally they would be suing the corporation. However, what some people don't know is they might also try to sue the president or one of the directors, the CEO. They may try to sue them personally. Okay, so that's what we're talking about here, director and officer liability. Now, in general, I think most people know that you have this corporate veil. But there are situations under established copyright case law, and I'm going to go over some of that with you here, where one, you can try to pierce the corporate veil, but number two, where officers and directors may be held liable because they're engaged. They're the ones committing the tortious act. They're involved. They have knowledge of it. So we're going to go over some of those situations where the officer or director, the IT director, let's say, may be held personally liable, and this is something that we think about in our software cases, okay? So I'm going to give you some of the words, some of the buzzwords, if you're the top brass over here and you're involved in a software audit, and let's say that you received a financial benefit from it, you're the CEO, you profit from it, that could come into play. What if you authorized it? You said, hey, I want you guys to install some software over here. You know, just who cares? Find it on the internet. We'll pay later. Don't worry. Use crack codes? Yes, go ahead. Use crack codes. No problem. So if you're directing or authorizing that sort of infringing conduct, you may be named personally. Again, directed, participating. That's another way to say it. You're participating. Another one is just where you're aware. In other words, you go, I see what's going on here. Wow, we all have the latest, greatest version of Autodesk in our architect or engineering firm. Wow, I don't know where we got it, but hey, the business is good, let's let the good times roll. That's awareness of it. That's the ability to do something. That's the ability to supervise, and doing nothing about it could lead to potential liability. Okay, awareness, again, that's what we talked about. Approval, ratification. and where you have a reason to be aware. So I'm going to give you a couple quick cases. We're going to wrap this video up here, short, sweet, in case you're doing your research in this area and you say, I have to know the specific language. I have a case here, Shapiro Bernstein and Company versus H.L. Green. You can find that at 316 Federal 2nd 304. That's a Second Circuit case. And that talked about promoting or inducing the infringing acts could lead all officers and directors to be jointly and severally liable. That means either one or both or all are liable. So that can be a really difficult situation. But promoting or inducing the infringing conduct, install this, install that, we'll go buy that cheap piece of cheap software off the internet, nobody's going to know, don't worry about it. Those kinds of things can lead to problems. Okay, so there's a case for you. And by the way, some of these cases are given to me by opposing counsel, just to let you know. We can't get a software case worked out, and they say, you know, you can just let your officers and your directors know that we'll be going after them personally, okay? So some of this case law is from them telling me, here it is, this is what we have, okay? So we have another case, Screen Gems Columbia Music, Inc. versus Mark V Records, Inc. This is a case that says similarly, I'm just going to quote some language from the case, similarly, one who, with knowledge of the infringing activity, so you have the knowledge, induces, causes, or materially contributes to the infringing conduct of another may be held liable as a contributory infringer. Okay, so that's another important case. So there you have knowledge, inducing, causing. So there's something going on. They're involved somehow in this infringing activity, okay? If it were shown to have knowledge or reason to know, okay, again, this is what we call the burying your head in the sand approach. You're just going like, you know, everything's going well. I know we've got some new employees. I know we're not really paying for new software, but, you know, we'll figure it out later. That approach can get you in trouble, okay? We have another one here, Pinkham versus Sara Lee Corp. I assume that's probably the cake company, but I'd have to look it up. But it talks about a corporate officer who has the ability to supervise infringing activity and has a financial interest in that activity, hits the good old pocketbook, or who personally participates in infringing activity, and we talked about that. In other words, sometimes we have small businesses where it's mom and pop, and you know, the mom or the husband or the kids, or maybe you have a student come in, install a student version. So they're in small companies. It's really what they sometimes call closely held companies. You can find this kind of thing going on, okay? There's another case here, 8th Circuit case. This is, you know, the federal courts are broken into circuits. The right and ability to supervise infringing activity and an obvious and direct financial interest in exploitation of copyrighted materials. So when we talk copyrighted materials, we could be talking software, videos, music, books. It doesn't really matter. Whatever your organization is engaged in, if you're downloading things, you're buying buying copyrighted products that nobody has a right to sell, that's raised issues. If you're buying things like counterfeit or infringing goods, that can be a problem. So those kinds of things. And what else do we have? I'll give you one last one. Here's from the 5th Circuit. This is out of Texas, Southern District. We have Fermata International Melodies, probably dealing with music, versus Champions Golf Club. You know, so that one looks like that was a case that talked about all participants who may be found to be engaging in the infringing activity could be held jointly and severally liable. You can look that case up, 712 Federal Sup 1257 for you legal buffs out there. And again, so it talks about having a financial stake in the infringing activity, so forth and so on. So those are a few cases, and you know, like I said, if you get involved in these situations where you're getting a DMCA takedown notice, a copyright infringement letter, you're getting a demand from either the BSA or SIIA or one of these other software publishers that are demanding that you engage in an audit like Adobe, you know, we can help you. We've helped lots of companies across the United States handle these copyright infringement notices. So if you need some help, we're here. You can find out more information about our software audit side of the business That's at softwareauditlawyers.com. We have some other information about BitTorrent and copyright bully letters in general. You can find that at copyrightbully.com. So we have two different areas, lots of resources, videos, podcasts, all kinds of things there for you to help you understand these types of situations. So if you need a lawyer, give us a call. We're happy to help. And in most cases, we offer a free initial consultation unless you're involved in a hardcore litigation. You know, we have to see the documents and so forth and so on. But give us a call. We're happy to help, and we have helped lots of other companies. So we appreciate it. We hope you like this video. If you like it, feel free to share it on your social media networks. You have our permission. And don't forget to click the V, the red V for victory, to get free legal updates coming to your inbox. Okay? Attorney Steve Vondran, we're out. Have a great day.